How do I respond to a restraining order of protection in New Mexico? Have you been hit with a restraining order? Has an ex or another family member filed a petition for order of protection and you've been served with a temporary restraining order and there's a hearing set? If so, you can respond. You can file a response to the petition denying the allegations. Alternatively, you can also potentially file a counter-petition for order of protection. If your ex or a family member is saying you have abused them, maybe it's harassment, breaking property, threats, physical harm, anything that constitutes an act of abuse under the Family Violence Protection Act, if they're claiming that they've been abused, you can likewise file a counter-petition that lists abuse. Nowadays, you no longer have to show that the act of abuse presents an immediate threat of harm. A few years ago, before a Supreme Court case, you'd have to show that there was an act of abuse that posed an immediate threat of harm, and most of the restraining order courts would limit the testimony to 6 months if something's happened within 6 months, because if it was longer than that, then they would say, well, there's not an immediate threat of harm. That all was changed with the Supreme Court case, and now it's fair game for basically anything in the past to come up. So if there was abuse in your past, you can file a counter petition for order of protection. Then when there's a hearing set, the hearing officer is going to need to hear the petition and then the counter petition and decide, is an order of protection going to be entered? Basically, the hearing officer can either enter the order of protection against one party, enter an order of protection against both parties if a counter petition is filed, or dismiss both potentially. And that is how you respond to a restraining order of protection in New Mexico.